Now we are taking study section 8 of administrative law, and study section 8 borders on pre-action notice. And at the end of this study section, you should be able to explain the meaning of pre-action notice. You should be able to state and explain the rationale, the reason for pre-action notice. And lastly, we should be able to explain the effect of non-compliance with pre-action notice. These are what we are expected to know at the end of this study section. We start on with pre-action notice. What is a pre-action notice? A pre-action notice has been defined as a notice of intended legal action, which a statute or civil procedure of rules of law requires to be given to the would-be defendant to enable him or her to decide whether to make a reparation or amend to the plaintiff or let the matter go to court for determination. It is usually a form of letter written by potential plaintiff or his client or his counsel to a potential defendant. What we are simply saying that a pre-action notice is a notice that is written either by the person who suffered an injury or by his lawyer to the person who caused the injury, stating the injury he has caused and the intention of that person to go to court. The person the letter is being written to is called intended defendant. And you that is writing the letter, you are the person who suffered loss and can be called an intended claimant. So a letter that is written by a person who suffered loss, who is aggrieved on a particular thing, to the person who causes that grievances or who causes that injury, stating the injury the person has caused and the intention of that person of going to court and what you are likely to demand for. That letter, that document is what is called a pre-action notice. So where the law says that a pre-action notice must be written, it must be written. So we're saying that the pre-action notice is what the law provides, is what the procedure of the court provides, that must be written by the person who suffered injury to the person who caused the injury, and the person who caused the injury is called the intended defendant, stating the injury he has caused, what you are likely to ask for in court, and the reason why you are going to court. And that is what we refer to as pre-action notice. There are laws in our country, and that law is what is called statutory provision. When you say statutory provision, this is what the law has provided. Under section 43, subsection 2 of the Asset Management Company of Nigeria, 2010, provide no action shall be commenced against the corporation until after the expiration of 30 days notice in writing to the corporation, given details of the alleged wrong, the date, and the remedy sought. What is the implication of this statement? It is to the effect that before AMCON can be taken to court, before you take AMCON to court, you must write a notice of your intention of taking them to court, and you must give them a minimum of 30 days notice. And in that notice you are given to them, you must specifically state the wrong they have done, the date for which the wrong was done, and the remedy you are going to ask from the court. That this letter must be communicated to AMCON, and 30 days notice must be given to them. That if you commence any action before this period, that action shall be null and void to the extent to which it does not conform with it. The same provision is contained under section 12, subsection 2 of the National Petroleum Corporation Act, but it specifies that at the expiration of 1 month in writing, meaning that for you to take NNPC to court, you must give NNPC a statutory notice of 1 month. Where you do not give them a notice of 1 month before taking to court, there is no way you can enforce any action against them in court. So that notice you are given to that body before taking them to court is what is referred to as pre-action notice. What is the rationale? What is the advantage? What is the basis of pre-action notice? These are some of the bases of pre-action notice. Number one, a pre-action notice necessitated to give the defendant a breathing time so as to enable him determine whether I should make amend to the plaintiff. That is one of the advantage of the pre-action notice, is that it gives the person who has caused the injury time to see if he's going to amend his way and compensate the defendant without necessarily going to court. Number two advantage is that it is a compulsory thing that is mandated by the statute, and it has to be done. That is, the law provides that before you commence an action in court, notices must be given. But this does not include in a criminal matter. In a criminal matter, there is no need for notices. But when it is a civil matter, notices are compulsory. Also, in a fundamental right issue, notices are not required. Number three, the major purpose of pre-action notice is to promote or to encourage out-of-court settlement. When notices are given, it will give parties the opportunities that they can settle the problem without necessarily going to court. So when a person who suffer loss, when a person who suffer injury decided to write to the person who caused the injury and stating what he has caused, the date he has caused it, and the remedy sought, parties can come together and resolve the matter. So number three advantage of the pre-action notice is that it gives room for out-of-court settlement. And this was established in the case of NNPCs versus Ganifa-Wayemi, 1998, 7 Nigeria Weekly Law Report at part 559 at page 598. These are some of the advantages of pre-action notice. Then, what are the disadvantages of pre-action notice? Because this pre-action notice also has its disadvantage. What are the disadvantages of pre-action notice? With respect to cost and time saving, the requirement to issue a pre-action notice may be counterproductive, where parties may be unable to reach settlement at the end. Meaning that when pre-action notice is made compulsory and the person who suffer loss has contacted lawyer to write notice and does a lot of things, spend a lot of money, and at the end of the day, there was no resolution. In that case, a lot of money has been wasted, a lot of time has been wasted, writing of letter, moving of correspondence from one place to another. So we now say that one of the disadvantages of pre-action notice is that it is not cost effective, and it does not save time, it consumes time. Number two disadvantage, the obligation to issue pre-action notice also raises a number of issues to access to justice, especially for individual litigants, as non-conformity may nullify the suit. What are we trying to say in essence? That the pre-action notice as a prerequisite, as a fundamental requirement that is necessary to issue a civil action in court, is not favorable to individual litigants that may not be conversant with the requirement of law. Because once they do not conform with this principle and their matter goes to court, their matter will be thrown out of the court for not complying with the provision of the statute. We're not saying that pre-action notice is not good to individual litigants that may not understand or may not be aware of pre-action notice and their matter being thrown out because of this lack of knowledge that is required. Number three, the obligation to issue pre-action notice may open a battlefield for satellite litigation by way of interlocutory application as to whether the party has or has not complied with relevant statutes. This is a very clear fact that when pre-action notices are not issued, or when pre-action notices are issued to some clients, parties can start going to court, filing an ex parte application where the other party will not be aware, to stop, to continue, to discontinue a lot of matter, that the pre-action notice open field for the other party to start filing a lot of frivolous application in court. And all of this are being viewed as the disadvantages of pre-action notice. We move on lastly to look at what are the effects of non-compliance with pre-action notice. That if pre-action notice is a statutory requirement that is expected to be issued by the litigant to the intended defendant, and this pre-action notice is not issued to the defendant, to be defendant, what are the effects of not complying with this principle? We say number one, in the event that the would-be plaintiff fail to issue pre-action notice where so required by statute, any suit filed against the defendant, such statutory body will be rendered incompetent. And this has been heard in a plethora of cases, like in the case of Peter Bellamy versus NNPC. What this is saying, that where the statute provides that statutory notice or pre-action notice should be issued to a body corporate, should be issued to a body before the body is being taken to court, and failure to issue that notice will render any process filed against that statutory body incompetent, and the court will set it aside. Number two, failure to serve a pre-action notice on a defendant gives such a defendant the right to insist on such notice before the plaintiff may approach the court. In other words, non-service of pre-action notice may merely put jurisdiction of the court on hold pending the compliance of the pre-action condition. What is fundamental here is that where the pre-action notice is being provided for in law, that it must be served by the person who suffered loss to the person who created the loss, that is the defendant. And if the plaintiff or the claimant fail to serve that pre-action notice, the defendant may raise the issue of jurisdiction, that the court will lack jurisdiction to entertain the matter because the precondition for which the litigant is expected to serve notice has not been done. We are not saying that everything filed by the court will be thrown out of the court because the pre-action notice is not served. And lastly, failure to serve pre-action notice amount to irregularity that render the suit incompetent, meaning that where the law provides that pre-action notice need to be served on the defendant and the plaintiff or the claimant fails or refuses to serve pre-action notice and decided to go to court, all processes served by the counsel of the claimant, by the counsel of the plaintiff, shall be incompetent and shall be struck out for non-compliance with the pre-action statutory provision. Thank you very much. We'll meet again in the next class. Thank you.